else. The question is that the motion be agreed to.
Mr Speaker.
Honourable Leanne Dalziel.
Mr Speaker, as the Minister has said, Labor supports this bill and have supported it since its introduction on the 20th of April 2011. And I do want to comment just briefly on the length of time it has taken to get this law to this point in this House, just concluding its second reading on the last sitting day of this year, 2012. It was referred to the Select Committee on the 9th of February this year, which does show that it sat on the order paper prior to the general election and wasn't dealt with until then. A closing date for submissions was on the 29th of March 2012. And as the Minister has said, they've received 90 submissions, hearing 60 of them. Now, unfortunately, I'm not on that select committee, so I'm not able to kind of traverse all of the detail of the legislation, which I would have, of the legislation in terms of the response of the select committee. But I do have one of the one of the departmental reports that I do want to refer to in relation to the last matter that the Minister concluded on, which is the question of unconscionability. And I know that, I've been on the record as the spokesperson in support of unconscionability going into our law. I understand why the government has adopted this particular point of view, but I think that it is probably a little bit unfair just simply to mention that some submitters commented on it, because I want to put on the record who supported the introduction of unconscionability provisions and who was opposed. So let's start with the list of those who were opposed to the unconscionability provisions. And I'm reading from the departmental report. Various submitters opposed, including the concept of unconscionability in the FTA, not the Free Trade Agreement, but the Fair Trading Act, including Fonterra, Business New Zealand, Telecom, New Zealand Retailers Association and the New Zealand Chamber of Commerce. So those were the ones who were opposed to writing unconscionability into our Fair Trading Act, as the Australians have done. Submitters in favour of introducing unconscionability provisions include the Salvation Army, Consumer New Zealand, the Citizens Advice Bureau, the Whitireia Community Law Centre, the Commerce Commission and the Motor Trade Association. What's the difference between those who support the introduction of the unconscionability provisions and those who oppose? I would suspect that the ones who are in support of the unconscionability provisions being written into the Act are actually those that are dealing with people day in, day out, who are the subject of unconscionable behaviour. Now, I want to talk about unconscionable behaviour because unconscionable behaviour is occurring daily in Christchurch. Every single day, my colleagues and I are approached by people who are dealing with insurance companies who are trying to evade the obligations that they signed up to when they were perfectly happy to take the Premier off our constituents, off the people of Christchurch, year in, year out. And what's happening now? We have elderly people being told by their insurance companies that they have no option other than to accept an unconscionable offer, because they do not think that they're going to be around long enough to see their property rebuilt. So if the government really wanted to address one of the major problems that is being confronted in Christchurch at the moment, they would be looking seriously at this unconscionable provision, and they would be looking at who supports it and who doesn't. And on a daily basis, as I say, there are all sorts of concerns being raised. Let me just read into the record the purpose clause from the new fair trading legislation as it was introduced, and then how the Select Committee has addressed it. The purpose of this Act is to contribute to a trading environment in which trading is fair and there is effective competition and consumers and businesses participate confidently. This was changed in the Select Committee to read, "The purpose of this Act is to contribute to a trading environment in which the interests of consumers are protected and businesses compete effectively and consumers and businesses participate confidently." And I think the Select Committee's actually got that right. I think they shifted the balance when they reasserted the purpose clause in the way that they have. Because I think that there is an assumption, there's certainly in the case in Christchurch, people feel that the marketplace is actually what they've been abandoned to on their own. That there are instances where the government actually does have to put their hands on, and there are instances where the market does not actually supply the answer, particularly when there is an inequality of knowledge, so that there's a discrepancy between what the company knows and what the consumer knows, and also when people don't think that they've got any real choices in the matter. And that's where this question of the interests of consumers being protected, because it is not equal in the marketplace in all instances. If somebody walks into a shop and they see an item that they want to buy, if the price is right, then they will buy it. Their interests are protected in the market in that regard. But their interests may not be protected if the owner of the particular product or the service that they're selling knows more than that person about what they're buying, and that they know that there isn't fair value, or that they know that they're buying something that isn't safe or up to a particular standard. And that is an issue that is dealt with a little bit in this legislation, but actually there's a little bit more work that needs to be done. What we haven't managed to get to in this country, and I noticed that the standards legislation has fallen off the order paper, but what we need to get to in this country is an ability to have the public good standards written on behalf of the public good, with public good funding that isn't dependent on the private sector or an individual government department taking referring a matter to the standards. To Standards New Zealand in order for a standard to be written. We actually do have to do better than that, because there are instances where people couldn't possibly have the same amount of information as the owner of the product or the supplier of the service, couldn't possibly be in the same position as them, and we do need a law that protects them better than even this law will do. We agree with the original concept that I think the Minister left out of his list, the Honourable Heather Roy, because in fact she was the one that was the enthusiastic individual who promoted the one law, one door mantra, and we haven't got there yet. And that's something that I think we do need to think about, whether we can in fact get to that point. But I want to place on record that the Prime Minister of New Zealand told Christchurch that he would be there for them, that he would walk alongside them. There are instances. Nobody would be worse off. I mean, but that's long gone, that one. I think the word that I hear more often in Christchurch in relation to that matter, Mr. Cosgrove, is the word disappointed. Every single day I hear people saying that they are disappointed. There are others who are angry and feel betrayed. But in terms of the consumer rights, the protection that he promised would be there hasn't been there. People have been abandoned to deal with their insurance companies alone, and nobody is standing alongside them. We are having people come to us on a daily basis who are not coping, and I am deeply concerned at the psychological damage that is being done. There are people in our areas who are suicidal, Mr. Speaker, because of the pressure that they're being placed under by the rapacious insurance companies. And if we are seriously going to address consumer law reform, then this bill doesn't quite go far enough. So we will be supporting this bill. Of course, it's an improvement on what the current law is, but it doesn't by any means let anyone off the hook for the real reform that's yet to come.
Jonathan Young.
Mr Speaker, I'm very pleased to stand at this second reading of the consumer law reform. A review of consumer laws commenced in November 2009 with the then Minister of Consumer Affairs presenting to Consumer and